Is there a limit to the number of exhibits we actually introduce during the course of your trial? Would you like to learn the answer? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you brought a lawsuit against your doctor claiming that he was careless. Your doctor denies those allegations. You claim that your doctor's carelessness caused you harm and injury. Your doctor denies those allegations as well. And you also claim that the doctor's carelessness caused you significant harm and injury and that your injuries are in fact permanent. And again, your doctor denies that anything he did caused or contributed to your injuries, and he says, you know what, even if you did get injured, so what? Your injuries really are not as bad as you claim. Those are the typical defenses we see in these medical malpractice cases. So now, your case goes all the way through the litigation process. The defense is refusing to negotiate. They refuse to accept responsibility. Now, what does that mean? It means that your case is going to trial. So now your case finally gets to trial, maybe 2 or 3 years down the road, because that's how long these cases take in New York. And now your attorney makes opening arguments. The defense makes opening arguments, and now you start taking testimony. And now over the course of the next week or two, there's lots of testimony, there's lots of antagonism, there's lots of infighting that goes on in the courtroom. And you're sitting in the back of the courtroom watching all these proceedings, and you're wondering, is there a limit to how many exhibits that your attorney, the plaintiff's attorney, can actually use at the time of trial? And the answer is no, there is no limit to the number of exhibits that your attorney can use at trial. Now, I should first explain, what are exhibits? Exhibits are things that we use to help the jury understand different concepts, different testimony, things that are going on during the course of your lawsuit. An exhibit can be anything. It can be a piece of paper. It can be an anatomical model. It can be a photograph. An exhibit is any piece of evidence that we want to show the witness. It's something that we want to have the witness explain. Hey, doctor, I'm going to show you this particular progress note. Looking at this line, can you tell the jury what this says? Okay, fine. Now I can go ahead and use that piece of paper as a trial exhibit. And whether that means that we have 5 exhibits, or 50 exhibits, or 500 exhibits, the bottom line is that there is no specific limit to how many we can actually use. Now, is there a preference to how many we should use? No, there is no preference, because there may be many instances where we're asking a witness to look at various documents, various models, various drawings, and now we need them to explain certain things. And every time we want to use a particular document as an exhibit, we have to identify it for the court. And why is that done? It's for the purposes of preserving the information in the trial transcript and also on appeal. Because remember, all the information, everything that is said in the courtroom is recorded by a court stenographer. And the person reading the transcript later on after trial is typically an appellate court. The judges at the appellate court will go ahead, if this is appealed, and read the transcript. And now if we are using a document that has not been identified, now the people reading the transcript will have no idea what it is that we're actually showing the witness. Dr. Jones, I'm going to show you a document that is part of the hospital record, page 17. It says, it's titled Progress Notes. Do you see that? Yes. Okay, fine. Your Honor, at this time I ask that this document be marked as Plaintiff's Exhibit Number 1. Fine, so mark it. Now what does that mean? It means that we have simply used an identification method, a system, to go ahead and mark it so that now everybody in the courtroom understands that this document is marked as Plaintiff's Exhibit Number 1. And now, does that mean it's in evidence? No, that's not what it means. It simply means that now everybody knows what this document is. Now I can ask my expert questions about it, and if I want to go ahead and show it to the jury, if it's that important, now I have to go ahead and lay a foundation to establish certain things, such as authenticity, for the purposes of getting this in front of the jury, in order to first get it admitted into evidence. If the judge allows it into evidence, now I can show it to the jury, which means that if it is in evidence, at the end of the trial, when the jury goes back to deliberate, to decide who is more likely right than wrong, the jury can actually look at that document during the course of their deliberations. If the document is not in evidence, then guess what? They cannot take it back with them to now review it and evaluate it in the jury room. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens during the course of these medical malpractice trials in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.